All right, we're going to call this hearing to order. If you could please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, present today is Member Clerk Bilski, Member Sue Styland, myself, Member Christina Knightsky-Troicke, and Attorney Mike Carroll.
We have the attorneys for the parties represent or identify themselves on the record.
Good afternoon. My name is Alan Brueggemann. I represent 13 of the circulators of petitions and the applicants for a position on the ballot.
Can you state your name again? I didn't catch that.
Alan Brueggemann.
In council, we talked beforehand. You said all but Mr. Gutierrez is your client. Is that correct?
Yes.
Is Mr. Gutierrez in the audience?
No, Mr. Gutierrez is not.
Okay.
He's not one of them.
Okay.
Jennifer Consolino.
And
My name is Pericles Abbasi, first name Pericles, last name Abbasi. I go by Perry with Chicago Law LLC, and I represent the objector, Craig Carlson, in every case except 12. In case 12, I represent the candidate, Nicholas Muller.
Thank you. At the last meeting, we adopted the rules of the hearing. I will not allow any outbursts, any talks, any conversations taking place during this meeting. There will be no pacing of the room. If you need to use the restroom, please see your way out the door and find your way back to your seat. We're going to move on. The attorney, once you're ready.
Thank you, Madam Chair. I do have a couple of items I'd like to address with your permission.
Yes.
So, as the attorneys for the parties will recall, at the last hearing, we set a briefing schedule, and we set a schedule for them to request any subpoenas to be issued. The board received one request, and that was from Mr. Abbasi to issue a subpoena in the matter of Cesar Marin. I did get a subpoena return. I have a concern about it, so I would like both attorneys to come up so I could give them a copy first before I transmit the subpoena return to the electoral board. And my concern, one of the reasons I want to address this is because Mr. Marin is represented by Mr. Brueggemann. So if you'll look at the affidavit that's been submitted to the electoral board, there are two exhibits attached. Exhibit B is the one I have concerns about because it specifically identifies the candidate's minor child. So if you have no objection to that being transmitted to the electoral board, I'll transmit it as presented by the attorney for the the witness. If you have a concern about it, then I would ask the two of you to go in the hallway and work out a stipulation on how to get around that, and I would redact that exhibit from the subpoena return before I give it to the electoral board.
you're talking about this guardian ad litem report?
Correct.
It should be deleted entirely.
No, it should not. There's some relevance there, but I do have a concern about the identification of the minor child, which is why I
I have no objection to blacking out the child's name, name.
And I got the entire report that's taken in different proceedings for different subjects. It has nothing to do with this hearing.
okay, well, that objection will have to be ruled on by the board, but let's,
What's the date of this? February 6th? How's that even relevant today?
of course, Mr. Abbasi asked for the subpoena to be issued. It was issued at his request by the board.
That doesn't mean the documents in the
Right.
subpoena are admissible.
Okay. If you want to,
May I have a copy of the subpoena that was issued?
it was already sent to you, but yes, I'll give you another copy if you want. Sent to your assistant, Laura. Before it was sent out.
With the return?
No, the return just came in yesterday. That's why I'm presenting it now.
That's why I want the subpoena with the return. Is the return usually part of the subpoena?
The return came in yesterday, as I mentioned, so I made copies of it. I had the concern about Exhibit B, which is why we're addressing it now.
This is not the return.
The subpoena was issued by an electoral board, not by the court. You're thinking about a court subpoena. That's not what we're dealing with
This is
here.
not a subpoena. This
Correct.
is a declaration.
Right, the subpoena was emailed to
It's not a
you.
subpoena.
Okay,
To issue.
right.
I'm want to see the return of this subpoena.
There is no return of the subpoena. The attorney for the declarant sent me this late yesterday evening, which is her affidavit, because she originally had objected to her appearance today because she had to work. She's an ER nurse, and if you take off anything the week of Thanksgiving, they get docked the entire week's pay. So she...
You're saying Michelle Navarro is an attorney?
No, her attorney contacted me. John Cullis.
Don't be an affidavit of
Okay.
an attorney.
All right. Well, you're arguing with me when they're going to have to rule on submissibility. I mean, legal argument. I'm not saying you're being argumentative.
But you're calling it something, and I want to make sure what you've given me.
Okay. We issued a subpoena for testimony of Michelle.
No, you didn't.
Okay.
This is not a return of a subpoena.
That's correct. So
This is what you're calling an affidavit, they're calling it a declaration.
correct. And the election code allows for affidavits in lieu of live testimony. So he sent that to me late last night.
It's not a notarized document either.
It's under penalty of perjury. If you look at the first, and there's a verification by certification in...
There's a verification supposedly,
Okay.
but there's no notary.
All right.
Okay?
So once you return to your seats, and you can argue the admission of this document, but in order to rule on it, and that's why I wanted to address it first, I have to give the full document to the board. Let the record reflect I'm tendering the declaration of Michelle E. Navarro to the 3 electoral board members so that counsel for the parties can argue as to its relevance and admissibility.
You want me to start?
Sure. Yes, your objection, yes.
Okay, addressing the election board.
Excuse me, sir, if you don't mind grabbing a microphone or turning it on. If you could use the one next to you, not that one. Use the one next to
The
you.
wired one?
Somebody on the village staff gave us this one. Okay, my name is Alan Brueggemann. I represent the candidates whose petitions are being challenged, except for one I disclosed to the village attorney. I've been furnished today a declaration, which was represented to be a return of a subpoena. This does not appear to be in any way a return of a subpoena. It contains a document from February, I think it is, February 6th of 2024, which is a summary of a person who's not appearing here today, not giving testimony today, and in no way is this a relevant document for a objection to a candidate's petition. There's also a declaration of Michelle Navarro. She's not present today. This is not a proper return of a summons or a subpoena. It's not her testimony, and it should not be admitted into evidence at all because it's an improper way of putting evidence in the record. I don't think there's even a proponent of this document to present it. If Mr. Abbasi is going to present it, I'll wait till he presents it for whatever he's presenting it for and repeat my objection without waiving anything today.
Mr. Abbasi?
Thank you, Mr. Carroll. I would like to present this declaration in the attached exhibits.
In support of which petition?
Counsel, don't interrupt his argument. He didn't interrupt yours.
In support of the objection case 01, Carlson versus Marine, specifically to paragraphs 5, or let me see, or 11 and 12 of the petitions, which state that Mr. Marine is not a resident of Homer Glen, nor does he reside at the address listed on his petitions, which is 13709 West Meath Drive. The declaration is from the reason the subpoena was requested is because This person, Michelle Navarro, does reside at 13709 West Meath Drive.
Objection, and ask that that be stricken as a issue of fact. Do you have personal knowledge of it, sir?
The declaration is...
The declaration is what you're
Mayor, may I?
submitting. You don't have to summarize it. You don't-
Counsel, we're not arguing back and forth. That's not how this process works. He's making his argument. You made your argument. You'll get a reply since it's your motion. Then I will advise the board and they'll rule on your objection.
Sir, he wasn't making an
Been interrupting him the
argument.
entire time he was talking. That's not proper.
He
I
stated a
was
fact.
asked why this is relevant to an objection. There is more to an objection than just signatures being registered voters or not. There are other issues at play, specifically in case 01, Mr. Marine's residency. This, the information contained therein speaks to his residency within Homer Glen and specifically at the address listed on his petition sheets, 13709 West Meath Drive. It's relevant, therefore, to paragraphs 11 and 12 of the objection. And as it is relevant to that, I would ask that it be admitted into evidence.
On which petitions? I really would like to know which petitions he's talking about.
Case 01, Carlson versus Caesar Marine, and specifically paragraphs 11 and 12.
And that's the only petition?
Yes, it's just for this one case, yes.
Okay.
I can tell.
Madam Chair, would the board like me to provide my opinion?
Did you have your,
Oh,
My objection is there's a lot of redactions. There's a report that was created in 2024, but February 6th. We don't know how that applies to the pertinent time of residency of a person, nor does it really even address residency. As I read this declaration, which is not sworn to before notary and not notarized, and I don't think it was properly returned. My objection is it doesn't state really what his legal residence is, and the legal residence of a voter is what is critical in the determination of their ability to sign a petition.
thank you. Attorney Carroll?
thank you, Madam Chair. So the issue here is that, as set forth in the last hearing date, the attorneys for both sides were advised of their ability to request this board to issue a subpoena. So Mr. Abbasi sent an email, carbon copied his opposing counsel, asking for a subpoena to be issued for the testimony of Michelle Navarro. In order to find an address with which to serve her a subpoena, I looked her up in Odyssey, which is the electronic filing system for most of the counties in Illinois, and I discovered that Mr. Marin and Ms. Navarro had a paternity case pending in the Circuit Court of the 12th Judicial Circuit in Will County. I discovered the attorney's name who was representing Ms. Navarro, contacted her. I did see in the docket that she had a motion to withdraw, so I didn't know she was going to be cooperative, but she was kind enough to reach out to Ms. Navarro and ask her to contact me so I could get her information to issue a subpoena. Instead, I got a phone call from an attorney, John Cullis, C-U-L-L-I-S, who informed me that Ms. Navarro was an ER nurse, that she was scheduled to work today, would not be able to attend today's hearing, was requesting a continuance. I explained to that attorney, who does not practice election law, that time is of the essence in these hearings, and that we couldn't kick this matter out past the beginning of the year because we had requirements under the statute to get information back to the Will County clerk. So in lieu of that, he promised to work out a declaration or affidavit, as the election code does allow for this board to take testimony by way of affidavit. It specifically mentions that multiple times in the election code. As to the issue of relevance, also when I checked the docket, I saw that Mr. Marin on the court docket identifies himself as a resident of Orland Park, but as Mr. Brugman has correctly pointed out, I'm not a witness either. So when I reached out to Ms. Navarro through her attorney, she confirmed that she has regular visits with her children when they're staying with Mr. Marin, that he resides in an apartment with his parents in Orland Park, and that to support her contention that he does not live at the Meath address in Homer Glen and has not for quite some time, since September of 2022, she submitted the report from the guardian ad litem, who also confirmed that at the time that guardian, who's an officer of the court, had visited with Mr. Marin and the children, it was at his parents' apartment where he was living in Orland Park. So my opinion is it's relevant. My opinion is that it meets the requirement of the election code for this board to take this testimony via this declaration. And my recommendation would be to overrule the objection and to allow its admission.
So it's up to this electoral board to decide if this stays.
If Mr. Brueggemann's objection is sustained, or if it's overruled and the document is admitted into evidence.
Can I state some basis for the objection? This declaration doesn't reflect that he has built a house in Homer Glen. He's closing on the purchase of the house, and he intends to reside in that house in the immediate future, within the month. I think he's closing in November, as a matter of fact, and his permanent residency has always been maintained as Homer Glen, and the fact that he lived temporarily elsewhere, he could have been in vacation in Florida for a year and still be a resident of Homer Glen and qualified to vote if he's not qualified to vote anywhere else. So I urge you not to accept this evidence because it's inadequate. It's based on information and belief. It's not stated on the facts. It's known where he lives on the date he signs the petition and what his permanent residence is.
Like to address that, Madam Chair?
Yes.
Okay. What counsel just indicated is absolutely not what the law says. The law says that in order to be on the ballot, Mr. Marin had to have resided at the address contained on his nominating papers, i.e. his statement of candidacy, his petitions, etc., for 1 year preceding the date of the election. At this point in time, this is considered a primary election because of the number of candidates that have submitted nominating papers. Therefore, the date in question would have been, he had to have been a resident at the address that he claimed on his nominating papers as of February of 2024. I believe that this declaration of Ms. Navarro, his former partner and the mother of his child, more than negates the presumption that we would give on his statement of candidacy and his other nominating papers. Calling it legal residence, there's a whole host of case law about what's required to show whether someone is a legal resident, and we have a statement from his former partner and the mother of his child that he has not lived at that address on West Meath since September of 2022.
I would further suggest I'm not allowed to challenge her bias. She obviously has a dispute with her former partner, the father of her child. The election, as I understand it, is February 25th, and this report of Jennifer Parker Ross, who has not given an affidavit or not verified her report, is from February 6th, 2024. So this time period is not relevant to the year before the election.
Madam Chair, may I make a point of order?
Yes.
So council's well aware this is not how objections are handled. He makes his objection. Mr. Abbasi was able to argue against it because he was the movant on the objection. He made his reply. Now, as I'm giving the board advice, he's trying to counter each and everything I'm saying. He's made his point. He's made his objection. I've given you my advice. I feel it would be appropriate to issue a ruling at this time.
Is there a motion to overrule Mr. Burgum's objection? Yes.
Overruled.
Sorry.
Second.
I also overrule.
Okay. So the ruling of the board is that the objection is overruled and the document is admitted into evidence. Is that correct?
Yes.
Okay.
So how are we going to proceed in case order?
Well, no, I also have some other preliminary items I would like to address. So what I'd like to do, unless the attorneys have an objection, we have, I think, 15 cases today. There are some that I believe they're kind of low-hanging fruit that we could probably address before the rest, so we can kick out at least as many as we can get done today. Members of the board, I had emailed you a motion to strike and dismiss the objector's petition with regards to the objections filed against Nicholas Muller in case HGMOEB12. I know I emailed, Mr. Abbas emailed it to me and his opposing counsel. I emailed it to each of the three of you. Are you all in receipt of that motion?
Yes.
Add extra copies if you don't. I will allow the attorneys to argue this, however, just so the board understands the motion, the basis of the motion is that Mr. Abbasi is saying, taking all the evidence alleged by the objector, Heidi Pasella, and the light most favorable to her, even if this board were to strike every one of the signatures she's asking you to strike, Mr. Muller still would have enough signatures. Am I accurately summarizing that, Mr. Abbasi?
That is correct. I went through Ms. Pacella's objection. I counted up. There were 5 sheets she objected to in their entirety because of notary issues. Those had 45 signatures. Additionally, she raised objections to an additional 50 signatures. Again, taken in the light most favorable to her, that would strike 95 signatures. Mr. Mueller submitted 196 signatures on his petitions. Doing subtraction, 196 minus 95 would give him 101 unchallenged signatures. The minimum, based on 1% of the vote cast in the last election for village president, which was 5,904 votes, would be 59.04, so it would be 60. And since 101 is greater than 60, even if every objection was sustained against signatures and pages, he would still have more than the legal minimum. So I'd ask that case 12 be dismissed and Mr. Mueller be certified to the ballot.
So, Madam Chair, with that being Mr. Abbasi's motion, Mr. Brueggemann would be granted an opportunity to respond, and then Mr. Abbasi would be allowed to reply, and then the board would rule.
Mr. Brueggemann,
I have no response.
is there a motion to dismiss the case of Heidi Pasella versus Nick Muller?
I so move.
Is there a second?
Second.
I also chose to dismiss.
Thank you.
Okay, and then also in the terms of what I'm referring to as low-hanging fruit, we now have a declaration of a witness for a candidate who is testifying via her declaration, and it's been admitted into evidence that that candidate does not live in Homer Glen. Does the board wish to take that up before having a full evidentiary hearing, because that's really the crux of the matter on their residency?
So you're proposing to bring case Carlson versus Marin next?
Well, there's an affidavit there, unless there's other testimony. I mean,
I'm fine with
I
that.
think that would be one of the quicker ones to get rid of. That's why I bring it up.
Member Bilski? Member Stylen?
Well, she seconded, so I just say,
Yes.
right?
Yeah, yes or no?
Yes.
Okay.
So what would be appropriate in that instance, Madam Chair, is if Mr. Abbasi has any other evidence in support of his objection, he would tender that at this time, and then Mr. Brueggemann, would be allowed to present any evidence he has, and then the board could rule on that petition or that objection.
Mr. Abbasi?
No further evidence in the Marine objection other than the declaration and the exhibits. And I'll include it. We talked about Exhibit B, but Exhibit A is additionally pay stubs from the entirety of 2024 showing that he has the Orland Park address, and the declaration is the person who owns and lives at 13709 Westmeath, saying that he does not reside there and has not resided there, which bridges the gap from the guardian ad litem, both the pay stubs and the declaration, from all the way from February 24 to the present day, through the date of his filing the petitions, that he was not in fact a Homer Glen resident at all, or not at the address 13709 Westmeath. So I ask that the objection be sustained and Mr. Marine be removed from the ballot.
Mr. Brueggemann?
I would respond again. This is not an affidavit. Mr. Abbasi actually calls it a declaration, and somebody has labeled it a declaration when they prepared it. In the language of it, it also says it's a declaration. I make this declaration. It doesn't say she affides to it. And an affidavit is a lot different than a declaration. Again, I think anybody can get a paycheck mailed to their bank, mailed to any address they want, and they don't have to have a residence at that address, nor does the fact that they get a paycheck at that address prove residency. Again, the article that's attached as summary report of the guardian ad litem in a divorce court certainly is not relevant to an election case. It's not a court determination, nor is it a request by a court to examine, to determine somebody's legal residence or the place that they declare as their residence for voting purposes, tax purposes, driver's license purposes, or any other purpose. The purpose for declaring a residence for voting is different than all of those, and so proof of anything other than voting is ineffective. And finally, again, I think the bias of the declarant is apparent from the type of the pleadings that are alleged or referred to in the summary. The summary of the GAL has privileged information. It's not intended for this purpose or any court proceeding other than the divorce case in which it was given. And the qualifications of the guardian ad litem, while maybe approved by the divorce court for the purpose of a divorce hearing, certainly doesn't have anything to do with election issues. Thank you.
Mr. Brueggemann, the chair has asked me to ask you if Mr. Marin is present.
Yes, he is.
Yes, he is. He intends to testify where his residence is, too.
Now would be the time to do that.
Well, are we proceeding through these one at a time, or are we going to jump around like you were doing, or is he going to present all his evidence and then we'll respond to all of his evidence?
No, what I recommended to the chair is that we deal with the ones that appear to be easiest to deal with from an evidentiary standpoint. And since Mr. Bassi said his only evidence is the declaration of Ms. Navarro, the only remaining evidence I would expect, and that's why the chair is asking you that question, would be the testimony of Mr. Marin. If we can get that kicked out, now we're down 2 or 3, so we're ahead of schedule.
Okay, so we will call him as a witness now.
Okay. Mr. Marin, can you go up to sit next to your attorney at the podium if you're here?
These are his first name, right?
Yes. Yes.
You can pull a chair up.
I will ask the court reporter to swear Mr. Marin in.
Stand up, raise your right hand.
You sound swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you.
Would you state your name and spell your last name?
Caesar E. Marine, M-A-R-I-N.
Are you closing on the purchase of a residence in Homer Glen very soon?
Today.
Today? Well, congratulations. At the time you were living with your partner or girlfriend, whatever her label might be, Michelle Navarro, you lived in Homer Glen?
Yes.
And how long had you lived in Homer Glen up until the date that you started to separate from her?
Approximately 18 years.
And was it your intention to remain in Homer Glen?
Yes.
So you were temporarily living elsewhere only because of the pending litigation between you and Ms. Navarro, is that correct?
Yes.
And you all the time intended this to be your permanent residence, and you claim it as your permanent residence?
Yes.
Did you list your Homer Glen address as your residence on any tax returns?
Yes.
Okay, thank you. What else did you list your Homer Glen address as your residence for in terms of official governmental requirements to have a residence?
Car insurance, bank statement, well, where I bank.
And in fact, you have your paycheck sent somewhere else than your former residence with your girlfriend in Homer Glen?
Yeah, it's direct deposited, but if I requested a check to be sent, yes.
Okay, so it is not delivered anywhere other than to your bank Is that correct? It's direct deposit? Is your bank in Homer Glen?
Yes,
So your checks are actually deposited in Homer Glen and have for the last year?
yes.
No problem. Don't worry about it. Was the separation from Michelle Navarro in 2023 a divorce action between non-spouses?
We were never legally married, we just had the ceremony. So it's just, I don't know how to call it, a separation or...
Okay. So was it adverse, meaning you were opposing her and she was opposing you and fighting over things that a lot of people fight over, and the breakup of a relationship, a partnership, a marriage?
Yes.
Have you ever known her to be untruthful?
Yes.
And in the divorce proceedings or separation proceedings, was she ever untruthful?
Yes.
Thank you. I have no further questions.
Mr. Abbasi?
Mr. Marine, when did you break up with Ms. Navarro, with Miss Michelle Navarro?
Officially, I can't say a date, it's just on and off.
The declaration says September 22. Does that sound about right?
No, because I was still living there till past that. I think she filed for, or I was served papers in April, I think. So September, yeah, the following year.
So April of 23.
I believe so, yes.
And since the breakup, have you lived together?
Well, we do. I mean, how personal is this going to get? I don't.
Did you live at any other address in Homer Glen since the breakup?
Yes.
Which address?
Well, which. Again, how personal is this going to get? I don't want to.
Madam Chair, may I?
Yes.
Yes.
I'm sorry, thank you. Mr. Marine, and I'm doing this, you're not a professional witness, and when everyone here, at least the attorneys and the board, understand that. But I'm always asked by electoral boards to make sure a witness knows when they give testimony under oath what that means. You understand what that means?
Yes.
Okay, understand that there could be penalties if you were to found to be telling something that was not truthful during your testimony. Okay, and so the ground rules we always do, whether it's a deposition or a courtroom, if Mr. Abbasi or Mr. Brueggemann or any of the electoral board members ask you a question that you understand, make sure you understand the question, okay? But, you know, I'm just trying to save us some time here, because asking an attorney how personal this is going to get, if his question were inappropriate, your attorney could object.
Mr. Carroll?
Yes.
I think he's indicating he doesn't want to answer it. He has a right not to answer questions, and that's not a perjury issue. That's a choice not to answer where he lived, where he spent the night, who might he have seen after he broke up with this lady, Miss Navarro. The question is his residence and his intention, not where he spent night in a motel with somebody, whether he was down on vacation in Florida, but what his intention is with regard to his residence. That's what defines a residence, your intention to live there.
Well, that's one of the several factors that defines residence. But I would agree with you. His declination to answer does not constitute perjury, and I will advise the board of the inferences they could take upon his refusal to answer a question. My concern was more, as I'm watching his testimony, to some of the answers he gave and the pauses and vocal tics he gave when Mr. Bassi asked him questions. I was trying to help him from getting himself into a trick bag. So I'll stop at that. Mr. Bassi, you can continue.
Are you familiar with the address 14551 South Ravinia Avenue, 1B in Orland Park?
Yes,
And what is that address?
my parents.
And it may sound a bit personal, but is that an address you've stayed at?
One of them, yes.
And you said you're closing on a house today, or you did?
Yes,
And what's the address of that house?
13158 West Sparrow Court. It's in Meadowview.
And how long were you under contract?
It's been, I think, maybe the end of September.
And how long before that were you looking?
I mean, really throughout the year, looking to get a bigger house for both my mom, my dad, my daughter, and myself. So it was tricky to try to find anything like that, and we were looking to build possibly or buy an existing home.
No further questions.
How long did your parents live at that address in Orland Park?
I want to say barely a year. We were living in Donwood.
Did you ever stay with them in Dunwood?
Well, they lived across the street from us in Donwood.
Okay.
So when we moved and sold, we stayed there, Michelle and I, until we moved to Erin Hills.
And that's that apartment that she listed as her address, or your address?
The house is under her mom's name.
Under her mom's name.
Her mom purchased the home on me.
Pardon? She purchased it from you?
No, Michelle's mother purchased the house on me,
On Mead.
the one in Erin Hills, where we live.
Is Meadowview in Homer Glen?
Yes,
And it was your intention from the time you moved out of that apartment with Michelle to locate a permanent residence in Homer Glen?
yes, I promised my daughter to buy the house that we lived in before in Donwood, but that was, they were asking for too much.
So you couldn't afford that, so you bought a different priced house, but still in Homer Glen?
Yes,
Okay. I have no further questions.
Mr. Abbasi?
Nothing further.
And sure, now would be appropriate if the electoral board members have any questions for Mr. Marine, this would be the time for them to ask.
Member Stylen, do you have any questions?
So you have no financial interest in the house on Meath?
You mean
So it's not
today?
your, it's not, it wasn't your, it wasn't.
You mean today?
You said it was the parents' or his girlfriend's mother's house?
What are you talking about? What time frame, I guess?
Well,
So Roman, handle it as a proper objection, and then the board can rule on that.
My objection was, what was the date she's asking about?
Well, October 17th, 24 is when he signed that he lived there on his statement of candidacy. So he wasn't living there.
No, are you asking a question or are you making a statement, ma'am? You get the right to ask questions.
Well, the
Bergman.
question is, if he had a financial, if he owned the home, I could see like moving out and, it's a temporary situation, but if he never, it was never his, ownership in the first place, I don't understand the connection to living there. Because it doesn't, you said that you moved out of Provencal. When did you move out of that residence?
in Donwood?
Yes.
I don't remember the year.
Oh,
Maybe 4 maybe years ago.
so you were living on Meath for how long?
Over a year, 2 years. we been there? 3? No, 2, I think 2 years we've been there.
Okay. Any further questions?
No.
Member Bilski?
My bad.
Mr. Marin, what is the address listed on your driver's license?
It's on me. I have a photocopy of it if you want to see.
Okay, what is your current address?
Pull it out and read it to us.
Attorney?
Oh, you don't.
Mr. Marin?
Yes.
What is your current address?
13158 Sparrow Court, Homer Glen, Illinois.
Sparrow Court?
Yes. It's in Meadowview.
Okay, your current address, you're closing today on your home, you said, correct?
Yes.
Did you close this morning?
Yes.
Okay. Where was your address yesterday?
I have 13709 listed on my bank statement, my car insurance, my driver's license.
You do understand the difference between residency and address, correct?
Where you sleep.
So where do you sleep?
Right now, I'm at my mom and my dad's.
Okay,
So
what is that address?
it's in Ravinia.
In Ravinia. And how long have you slept there consistently?
Consistently, I couldn't say. I mean, I stay with a roommate in Homer Glen. It just depends on my work schedule and when I have my daughter.
When was the last time you slept on Meath?
Let's see. Probably 2020. December 2023, maybe? Or
2023. You do understand that you have to have a residency in Homer Glen for 1 year prior to you signing your petition or election, or I'm sorry, petition filing date, correct? No, I'm sorry, before the election date, primary, February 25th of 23.
Okay.
24.
Or 24, I'm sorry, my dates are all confused. So if you slept or lived at Meath, on Meath Road, or Meath Drive, whatever it is, since February 25th of 2024.
If I live there,
Yes.
I think she asked if you slept there.
that's, you know, the last time I slept there, I told you
It was December of 23.
Maybe, I have to
Right.
check, I don't know, 2023 or, pretty sure 2023. Or 2022, I'm not sure.
Okay. Have you lived on Meath since December of 23 or February of 24?
No,
Okay, thank you. So by your own testimony, you have not lived on Meath since February of 24, as you just stated?
right.
Okay. Okay, so we're going to, is there a motion to
I would
sustain?
like to cross-examine him with regard to your questions of him.
That's appropriate.
Okay,
Sir, where's your bedroom furniture?
I have a bed, one of my, in
Excuse me, I
Meath.
didn't hear you, sir. We have a bed.
I have a bed on Meath.
In the house on Mead that you used to live in?
Yes, it's in the downstairs bedroom.
Okay. And you consider that your residence until you have a new residence, is that correct? Which is now today the new house in Meadowview?
Well, I mean, that's what I thought, yes.
Okay, thank you.
okay. Is that it? Do I have to go back and forth anymore?
Madam Chair, what probably would be appropriate is allow Mr. Abbasi to argue his objection, allow Mr. Brueggemann to respond to his argument, and Mr. Abbasi will get a reply, and then if the board members had a motion to address the objection, that would be the time.
Mr. Abbasi?
Yes, so what we have on the petitions and the statement of candidacy that he swore to is that he resides at 13709 West Meath in Homer Glen. Since at least December 2023, perhaps earlier, he has not spent the night there or lived there. He's said he's gone between a roommate in Homer Glen, his parents in Orland Park, he said that that they're trying to make the residency, it's, okay, he hasn't abandoned it, but, hasn't lived there. He's been looking for a new house for over a year, it sounds like. So that, together with the declaration, shows that there really has been no residential relationship with 13709 Meath for all of 2024, which is the relevant period from February 25th, 2024, a year before the election. As such, he's violated a mandatory provision of the election code, which is to list your address on the petitions. The statement of candidacy contains a false swearing that he resides there, and additionally, he's in violation of the Illinois Municipal Code, which requires residency of 1 year prior to election. Because of that, I ask that Mr. Carlson's objection to Mr. Marine be sustained and that he be removed from the ballot.
Thank you. He's testified his children live at the Meade address. His bed is at the Meade address. His driver's license is registered at the Meade address. He has no other domicile that he can lawfully use for registering to vote elsewhere or to call a residence elsewhere. So his residence is based on his intention to permanently live in Homer Glen, which he has clearly and expressly stated. The fact that his girlfriend filed some court action to challenge their relationship has nothing to do with his residency. And it is not left up to that court to determine his residency. Somebody asked about financial interest. He wasn't allowed to answer that. I'm not sure why, but he clearly has the intent to be a permanent resident of Homer Glen and has never changed that and hasn't ever registered to vote anywhere else. So his residency is Homer Glen.
Mr. Abbasi?
I think, so with his testimony and with the declaration that he moved into his parents' apartment and that from someone, we have a declaration from someone who actually does reside at 13709 West Meath, and that that Mr. Marine does not, in fact, reside there. We have that he was not a Homer Glen resident and not a resident at 13709 West Meath, so his petitions are in violation of the election code and the Illinois Municipal Code. And I ask the board sustain the objection and remove Mr. Marine from the ballot.
Okay. I'd like to make the motion to sustain the objection to Cesar Marine's petitions. Is there a second?
I'll second.
Okay, now we're open for discussion. So for me, based off of Mr. Marin's own testimony, he stated that he has not lived on Meath Drive for at least a year. According to the document that we received early today, or the exhibit, I should say, Mr. Marin has visitation with his child in Orland Park for over 2 years. I also feel that this is not a case of where his furniture resides or where his child resides. This is a case of where he resides. Is there any other comments, Member Bilski, Member Steinman?
Just that I don't understand why he couldn't register to vote in Orland Park. If he gets his pay stubs with an address, those are documents that you use to prove that you move somewhere. So I would question that as well.
Okay, the motion has been made. The second has been made. I'm going to call the roll. Member Bilski?
Aye.
Member Steilen?
Aye.
I will also say aye.
Madam Chair, the ruling of the board is that Mr. Marin be stricken from the voter or from the ballot, correct?
Correct.
The next item that appears should be a shorter hearing, and so with the chair's indulgence, there's the issue of candidate Fialco. Looking at the petition, it's alleged, if that's true, that the address that Mr. Fialco listed as his residence is in fact the UPS store in Homer Glen. So if the chair is interested, that might be one we could resolve in fairly short order.
Okay, we'll move to see case HGMOEB-3. Mr. Fialco.
No, Mr. Abbasi, it's his objection. He would get the opening statement if he wishes to make one. If not, if he wishes to make an opening statement.
I do, yes, and I'm just pulling up the Mr. Fialco's objection. So Mr. Fialco's petition and statement of candidacy state that he resides at 14007 South Bell Road, apartment 235 in Homer Glen. I would like to submit into evidence, I stopped by on the way here, 14007 South Bell Road. I took pictures, I didn't have a chance to print them out, but I have business cards from the UPS store that is there that I would like to offer into evidence, and I have copies for opposing counsel as well. Also, I printed from UPS's website, or the UPS store website, that shows that they have the UPS store Homer Glen Crossings is at 14007 South Bell Road. I have an image from Google Maps of the UPS store with the 14007, and it says 14007 South Bell Road, and also printouts from Google. When you search Homer Glen UPS store, it says 14007 South Bell Road. Going in the UPS store, UPS stores have mailboxes. It appears there's a mailbox 235 in there, but it's a store, it's not a residence. And if I may, I'll offer these printouts in the business cards.
Yes, please.
Show them Mr. Brueggemann first, Mr. Abbasi.
You can just throw them up there, we'll pass them. Mr. Bergman, do you have any objections to these being submitted? Is it a group objection?
Yeah,
I mean, group
foundation.
exhibit?
Does that counsel see foundation?
Yes.
So, Madam Chair, can I explain what that objection is? So, in order to be entered into evidence, whether it be a photograph or a document, a witness would have to submit, for example, in the photograph, one of the foundational requirements is that a witness would testify that that photograph fairly and accurately depicted a scene as it was purported to depict. In this instance, Mr. Abbasi saying that he drove out there. I don't know if any of the electoral board members know that address is the UPS store, in which case you're certainly welcome as village officials to take judicial notice of the address, or if you want Mr. Abbasi to have a witness testify as to that address, he could perhaps get a continuance for that purpose, or wouldn't be the first time, the electoral board could take a field trip. So there's any number, yeah, what's that?
I was just there yesterday.
So with that, if the board were inclined, it could take judicial notice of the fact that the village clerk has personal knowledge that that address is in fact the UPS store. In and of themselves, Mr. Brueggemann's objection is probably valid on foundation, but you're allowed to take everything in its totality. He's got multiple documents, different searches. He's got photos on his phone. If he wants to show them to Mr. Brueggemann, he can email them to me, and I can distribute them via email to the board members. There's any number of ways you can handle that. So it's really the ruling of the board.
I'm sorry, I'm not a normal judge, so what's the ruling? What am I asking the board?
Well, he's objected to their admission into evidence. All you have to do is decide whether you want to take them in evidence or not. This is not a criminal courtroom. You are allowed to take hearsay into evidence as long as it's a type that would be reasonable, reliable by a reasonable person. And then you also have your board member who's familiar with that being the UPS store address. So do with that.
No, is there an objection?
There is an objection.
I'm
It's
sorry,
your ruling
is there a
on objection.
motion
Yeah.
to sustain the objection for the submittal of photo evidence?
So what that means, if you sustain the objection, it means it does not come in because
Right.
it is objecting to their admission. If you overrule the objection, they come in, or you could sustain the objection, don't let those documents in and take judicial notice of what Member Bielski said. You have several options here.
I'll make the motion to overrule the objection of the evidence. Is there a second?
I second.
Trustee Steinle?
Aye.
Okay, so the evidence will stay.
I have a witness I intend to call. I don't know if you're ready for that yet.
Is he ready to call?
Well, you would probably ask Mr. Boss if he had any other evidence to submit.
Do you have any other evidence to submit?
No, I have photographs that I could, the photographs I took on the way here that I could email later.
Proper to email photos later that he doesn't.
Excuse me,
present and show to me.
can we let him finish, please?
Yeah, I took them, like I said, I stopped by, I took some pictures on the way here, so I didn't have a chance to print, but, and I'll say, again, as with the previous case, the election code requires you to write on the petition sheet, have your place of residency, and also on your statement of candidacy, you swear that you reside at an address, as Mr. Fialco's statement of candidacy says, I swear that I reside at 14007 South Bell Road, as it is a UPS store. There are no apartments in there. It's a commercial store. He does not reside there. Again, that's the basis of the argument, that he does not reside at the UPS store, and as such, the objection of Mr. Carlson should be sustained, and his name should be removed from the ballot.
Mr. Brugman?
Well, I was objecting to the fact that he says he took some photographs on the way here. He doesn't have them developed yet. He doesn't know what they look like. He doesn't even know if they turned out, but he wants to file them later. That's an improper
Madam Chair, can I explain that?
presentation of evidence.
I think we all know where the UPS store is in Homer Glen. So
Well, that's not the question, ma'am. The question is whether he can submit photographs after the hearing is all over. You got to make
Okay.
a ruling on that.
Okay. Attorney Carroll?
Yes, I agree with Mr. Brugman on that, but the rules that were adopted at the last hearing say that all evidence or any motions, subpoenas, et cetera, flow through the board's attorney. So what I offered, I agree with Mr. Brugman that they cannot be submitted after the hearing today. So if Mr. Abbasi wants to submit them, he can email them to me now. Show them to Mr. Brugman first, of course. Then we would transmit them to the 3 board members. I've got my laptop right here. We could look at them on my screen, on your screen, whatever you'd like, and then we could deal with any objections if there are any. But I agree that they can't be submitted later.
Okay. And if I may show them to Mr. Brugman?
I don't feel it's necessary to have photos of the UPS store.
Okay. That's,
I mean, yeah, I have one already submitted. So, Mr. Brugman, do you have any evidence
Yes, I
you'd
do.
like to submit? Okay.
I'd call Mr. Danfield? Dan Fialco. Oh, coming over here. Stand up and be sworn as a witness. She's going to swear you in as a witness.
Sir, do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Have a seat. What is your name, sir?
Dan Fialco.
Are you related to a person who's filed a petition to be a candidate for the Homer Glen village election?
I am.
Who is that?
That's my son,
What is his name?
Ethan Fialco.
How old is Ethan?
He is 34.
Does he have a residence in Homer Glen?
He does.
And
Yes.
And how long has he had that residence in Homer Glen?
His own personal residence for over Over 10 years. And previous to that, he lived with us for his first 23 years.
So he's
of life.
lived all his life in Homer Glen.
Yes, sir.
You know what address is on his driver's license currently?
I do not know what's on his driver's license, but I do.
Go ahead, you can finish. I didn't mean to cut you off.
He does live on Sawgrass, though. His address is 14936 Sawgrass Lane, and if you look it up on Will County GIS mapping, it'll show that he's the taxpayer for that residence.
Thank you. Thank you. Wait.
Thank you, Trustee Fialco. Does your son...
If I could just not be referred to as Trustee Fialco at this point.
Okay, I apologize, sir. Mr. Fialco, so your son resides at 14936 Sawgrass Lane, correct?
That is correct.
He does not reside at 14007 South Bell Road, correct?
No.
Your son does not live in a UPS store, is that correct?
No, but that's his business address, yes.
Okay. No further questions.
No further questions.
No further questions?
I said no further questions.
Okay.
I'm sorry if you didn't hear me.
Anything from
Do you have any other evidence?
On this
Mr.
one,
Broom?
no.
No. All right, Mr. Carroll?
Thank you, Madam Chair. The issue here for the board to consider is not whether Mr. Fialco, Ethan Fialco, is a resident of Homer Glen. It's whether, in fact, he's a resident of 14007 South Bell Road, apartment 235, Homer Glen, Illinois 60491. The reason that's pertinent is because the statement of candidacy signed by Ethan D. Fialco under oath on October 21st, 24 alleged that he was a resident of that address. Further, all of the nominating papers that were submitted on behalf of, in support of Mr. Fialco's candidacy list his residential address as 14007 South Bell Road. The whole host of case law in Illinois with regards to nominating papers state that any falsehood with respect to the circulator's oath will be severely dealt with by electoral boards and the courts. It is in fact this oath that forms the basis for the type of disqualification seen in the pattern of cases discussed. In general, an oath is an affirmation of the truth of the contents of the documents attested or sworn to. It is, quote, a conscious calling upon an individual to subscribe to the truth, unquote, by which a person declares and attests that he or she is bound to act and speak truthfully in the presence of witnesses. In that case that I just cited is in re petition for removal of Rice at 35 Illap 2nd 79, 181 Northeast 2nd 742. Also that's cited in People ex rel City of Leland Grove versus City of Springfield, Illinois at 193 Illap 3rd 1022 and 550 Northeast 2nd 731. These cases have made their way from every appellate district in Illinois up to the Illinois Supreme Court, and misstatements of fact under oath on the nominating papers are one of the biggest bars to candidacy that are known in the election code. So based on that, that's the issue you have to decide if in fact he did reside at 14007 Bell Road, not whether he resided in Homer Glen.
May I respond?
Yes.
I think the real crux of whether it's a false petition is whether it's fraudulent and not whether he's incorrect. He has a driver's license with an address that's his business address. He's asked for his address. Who is to say he falsely reported that address when in fact he thinks that is his address, and it is in Homer Glen, and he also lives in Homer Glen. So there was no intentional falsehood by the candidate or with regard to his circumstances.
Madam Chair, may I make a point of order again? Again, counsel has gone completely out of order in that Mr. Abbasi was allowed to argue, he was allowed to respond, Mr. Abbasi was allowed to reply. I then made my legal opinion known to the board, and he wants to start debating it. That's not how these processes work. His time to speak has already come and gone.
I can't criticize your opinion until after you give it. Do you understand that?
I do, but I give my opinion after you've both argued your points, and that's what my role is as the attorney for the electoral board, and then they rule. That's how that works.
Maybe you should state your opinions before they rule and give everybody a chance to criticize your opinions. You're not the authority.
No, I'm their attorney to advise them, and case law is clear that lay people on an electoral board are allowed to involve their attorney in their decision-making process since they aren't attorneys. But you don't get to make the rules on in what order that goes. You make your arguments, they ask for my opinion, then they rule. That's the way their rules are adopted, that's the way the election code works.
Okay. So I'm sorry. Do I make the motion now? Do I make a motion or ask for a motion?
Either way.
All right. Is there a motion to sustain the objection to Ethan Fialco's petition for discussion?
I'll make that motion.
Is there a
A
second?
second.
Okay. Anybody like to speak first? Member Stylen?
Well, I can just say, I know where Ethan has a house, it's right around the corner from me, so I'm not going to hide that fact. I don't doubt that he might live there. I have no idea why he used this address unless he has intentions of moving, or as his father has stated, it's for a business. But as an electoral board and as, like when you fill out this paperwork, I mean, there's a reason that you put that you reside at an address. So I don't understand why this was done, but it's incorrect. And so that's what I just have to say. And there's a point where something is correct and it's not just a typographical error. There's a candidate's guide to read on how to fill out paperwork, and I just support the objection.
Member Bilski?
I agree with Member Stylen.
After reviewing his petitions, where you sign your name and print your name and where you put your address where you're registered to vote. And it also, where he signs his own petition, he signs that he lives or is registered to vote at 1400 South Bell Road, which we know that is incorrect. We know he's not registered to vote on Bell Road. We also know that he's not even registered to vote at the address he actually resides at. There's other challenges on his petition of duplicate signatures, and the number of signatures that also signed 4 or more petitions. Going by the notary date in which he submitted for these signatures, he's got a few pages that say they were submitted on October 20th and a few that say October 28th. Not just based on the address alone, there's other challenges that would fall into play here. So after reviewing all of the challenges plus the address, I agree with the motion to sustain the objection for Ethan Fialco.
Madam Chair.
Attorney Carroll.
Yes, thank you. My only suggestion would be what we're trying to accomplish is to deal with the faster issues. In this particular case, it's just the residency of Mr. Fialco. The points you made about the number of petitions a voter may have signed is almost universal across all of the objections that remain. So what I would recommend to the board to keep it clean would be only rule on the residency right now, and then when we deal with that issue on everybody, the attorneys are going to have to come up with a suggested solution on that, I would think. That will take a while. So what my thought is we only rule on the residency now, and then we'll deal with the other challenges to Mr. Fialco's nominating papers and signatures when we have that similar issue across the board. Does either attorney disagree with that?
I'm in agreement. Yes.
Okay. I think that would be the most prudent.
Mr. Burgum, you didn't respond.
I said no.
Okay.
You asked if we disagreed with it, and I said no.
Right.
I thought he said yes, but I...
Okay. You both agree that's the most prudent?
We're all on the same page on that one.
Okay.
Yes.
All right.
All right, so we're going to do the roll call. Member Bilski?
Aye.
Member Stylen?
Aye.
I vote aye as well.
I would like to make a motion to strike the testimony of the mayor because she said something about the residency on the registration of the candidate. And I don't think any evidence was presented on the registration of the candidate as to his residency. So I think it was improper to consider that, and it was improper for her to testify to that in her ruling without any foundation as to how she would know what his registered voting address is.
I'm sure.
Sustained. Fine, it will stay.
Okay, so you're striking that part of your, it's not testimony, it was a ruling, but you're striking that part of your ruling.
Sure.
Okay.
Okay, who's next?
All right, so the next item that I think might be something we can resolve relatively quickly is it came to my attention through the deputy clerk that 4 of the candidates that are being objected to have filed nominating petitions both for the office of trustee for the Village of Homer Glen and for the office of school board member on 1 or more school board races for the same election date. There are multiple opinions from the Illinois Attorney General's office declaring that school board member and municipal official, whether it be a city alderman or a village trustee, are what the law calls incompatible offices. What happens in that instance is that if someone files nominating papers for 2 incompatible races, they have until 5 days after the last day they could file nominating papers in those races to withdraw from one or the other, or they're stricken from both. The timeline for filing nominating papers for village trustee for Homer Glen is identical to the timeline for filing nominating papers for the 2 school boards. Therefore, the last day a candidate could file for either of those races was November 18th. 5 days from that would be November 23rd, which is on a weekend. The election code says if a deadline falls on a weekend, it goes to the end of the next business day, which would have been yesterday. If the parties wish her to testify, Deputy Clerk Marcotte is here. She checked this morning with the Will County Clerk, and the 4 candidates in question have not withdrawn from either race, and therefore by operation of law should be stricken from the ballots of both. I don't know how you attorneys want to handle that, whether you stipulate to that and we can resolve that promptly, or else we certainly could have Ms. Marcotte testify to her conversation with the Will County Clerk, and yes, while it's hearsay, the board can determine whether it's reasonably reliable, and they could take that testimony of hers if they wish. So I don't know how the 2 attorneys wish to proceed.
Would you give us a couple of minutes?
Absolutely. Yeah.
Sure. Take a, no, I don't want to take a recess.
You don't have to recess, just give
Okay.
me 2 minutes. I'll talk privately
We'll stay here.
with another person, and we'll be right back. We have some evidence to present on that, so I don't think we can stipulate.
Okay, that's
I
fine.
didn't talk to opposing counsel.
I'm sorry?
Back on the record. Excuse me. I started talking before we got the court reporter typing. I've had a conversation with my client. We have some evidence that we want to present on that issue, but I haven't had a chance to talk to Mr. Abbasi. I don't think it's a waste of time to talk to him, so I'll mention it to him.
So here's another thought, counsel. I don't know if you were advised by your partner, but I also have to serve, assist one of my associates as the administrative hearing officer for the village at 3. I don't think there's any other low-hanging fruit, so I prefer to keep going as long as we can up till 3 o'clock, so then I just have to go across the hall. There's only a few cases on the docket I have to rule on, and I'll be back. So we'll take a recess around there is what the chair had intended.
If you want to pass this, that's fine with me. We'll come back to it.
And I don't, yeah, we can, or go ahead.
So one of the other things I was just talking to the chair about while we're waiting for you to return, Mr. Brueggemann, it does appear that one of your clients has a similar issue to what Mr. Muller had for Mr. Bassi, in that as we're looking at the math, I believe, and you two can talk about that too, even if every one of Mr. Bassi's objections were sustained on Mr. Medelsky, there would still be enough signatures. So if you want to take a look at that, and if you agree with that, maybe we could do the same thing that we did for Mr. Muller.
Why wouldn't we?
Yeah, I have no objection to that. I did the math too. It's,
All
yeah,
right,
it's
so
correct.
you're withdrawing that objection?
Yeah, we'll withdraw that objection and.
Okay,
So Mr. Modelsky stays.
yes.
And then we're coming back to that other issue that we can talk about, the,
Well, let me ask you this, would you want to have Ms. Marcotte testify to her conversation, or do you trust that that's the fact that you just want to present your own evidence?
I don't think I care if she I mean, you've made a representation that she called the clerk and the clerk said
But she
that.
told me right before we started, yeah.
Right, I understand that, and I don't mind you putting that in evidence as her testimony.
Okay.
But I do have my own witnesses I want to call on that issue, so if you want to skip that and come back to that, or if you want to go forward, I'm not trying to run the show.
No, it's up to the chair. I'm just thinking, that maybe we can get that done in 45 minutes, and then we'll get into the meatier stuff, because I think that's the last of what I'm calling euphemistically.
I think we certainly can get it done in 45 minutes.
Want to do that?
Sure.
And,
Okay,
So I can keep going, and then you can take your break at 3.
perfect.
and perhaps so we're all in agreement, based on my reading of the list on the Will County Clerk's websites, the candidates under issue are Jennifer Troz Consolino, who filed for Homer Community Consolidated District 33C. There's, for Will County School District 92, John Walters, who also filed for trustee here. And then for Lockport Township High School District 205, I see Teresa Tammy Hayes and James J. Rohde. They filed for that school, the high school board, in addition to trustees here. Is that
That is correct.
okay?
Mr. Brueggemann?
Okay, I'm ready to present evidence if you're, would you step and be sworn, step up and, or stand up and be sworn?
You tell us whether the testimony you're about to give will be the truth, the whole truth, nothing but the truth, and nothing but the truth.
So cold in here.
I also think it's important to have Mr. Dan Fialco.
Well, I'm going to
Come
call
up
him
to us.
after you.
Oh,
if you
okay.
need to, but they may
Okay.
stipulate he
Um,
can't say anything.
I don't remember, oh, sorry. My name is Jennifer Troz Consolino.
And you're a candidate for office?
I'm a candidate for office for trustee for Village of Homer Glen and for school board for Homer 33C.
Did you happen to have a conversation with the county clerk regarding the requirements for running for 2 positions?
Yes, I did.
Was anybody else participating in a conference call with that call to the clerk?
Yes, there was.
Who was those people?
Dan Fialco.
Anybody else?
And then the employee, Nick, from the Will County Clerk's Office?
Okay, so Nick is the guy that handles the election contest?
Yes.
Okay, so when you talked to Nick, did you call him at the clerk's office?
Yes, I did.
And did you ask for him specifically?
No.
Did you ask for him by his position of authority?
Yes.
And he was the one that discussed with you your candidacy for Homer Glen and the school board?
Yes.
And do you remember approximately when that was?
This took place early October.
Well, when he had a conference call, were you and Mr. Falco in the same place, or were you at someplace?
So the reason there was the conference call was because we had initially put in a phone call to Nick. Nick had to do research on the subject because he had decided whether, and we asked for 2 questions. We were very specific. We asked, could we run for village trustee and run for school board? And then we asked, could a township or a person run for township trustee and run for school board? And so Nick went back through the statutes and some other information and precedents, and he called us back while I was on the phone with Mr. Fialco, and this is why we patched him in on conference call. And he explained that there was,
Objection, hearsay.
Boy.
Well, again, Madam Chair and board members, you are allowed to take in hearsay, but what she is talking about is basically double hearsay. A conversation someone else heard someone else saying, so you have to make a determination, is this something that's reasonably reliable? If so, you can hear it. If you don't think it is, you would sustain the objection.
I'm not exactly sure I heard what you said because that court reporter is sitting right between us. But I think she's saying that the clerk's office in Will County gave her an opinion over the phone, and 2 people listened in on that conversation. So she's giving you her recollection of what was said, and I assume Mr. DeFalco's testimony will be the same if you want.
I'm willing to overrule the objection.
Thank you.
Thank you.
And so what was explained to us both was that, yes, village trustee could run for school board and for the village, and that it was in no way a conflict of interest. And they also stated that if we ran for both, we could win both and do both. Also, when it came to the township, I was told no, because there was something with tax levies involved, so that a person could not run for township trustee and could not run for school board.
The school board that you're running for is what school board?
Homer 33C.
And who are the other candidates that were running for school boards?
And for village trustee, it's, I believe, Tammy Hayes, James Rhodey, and John Walters.
And did you share that information that you had obtained from the clerk with those other 3 candidates?
Yes, I did.
And so the 4 of you left your names on the ballot for both, I shouldn't say on the ballot, you left your names, you left your petitions filed asking to have your names on the ballots on both because of advice from the Will County clerk.
Yes, and I believe they did the same, and then that's the other reason why we did not submit petitions for school board or get them signed until after we had spoken to the Will County clerk.
Thank you, I have no further questions.
Mr. Abbasi?
Did you get advice from anyone else besides the Will County clerk?
No, because the Will County Clerk's office is in charge of it. And then I also saw Nick when I submitted my paperwork for school board last week.
And so you did in fact submit for both village trustee and school board. And have you withdrawn from either your petitions from either office?
No, I have not.
To your knowledge, have any of the other candidates such as Tammy Hayes, Jay Rhodey, or Mr. John Walters withdrawn any petitions for either office?
I don't believe they have.
No further questions.
Mr. Burgum?
When you filed your petitions for school board, you said you met with Nick, the guy from the clerk's office who gave you that advice.
Yes.
Did you reiterate your conversation with him about your filing for the second office?
Yes, because he overlooked all my paperwork.
Okay. And he approved your paperwork?
Yes, he even notarized one of the sheets.
And he approved your filing for 2 positions?
Yes.
Thank you. No further questions.
Does any of the board have any questions? Members of the boards have any questions for Ms. Consolino?
Did you consult an attorney?
No, I did not.
Member Bilski?
Do you have a child that attends Homer 33C?
I don't see how that's relevant. I don't see how that's relevant.
Ms. Consolino, you're aware of the state statute, correct?
Which one?
And you're aware of the Illinois state statutes, any of them? You're aware, are you aware? Okay. Are you aware, how do I rephrase this? There is a state statute, Trustee Consolino, that reads.
Could you please call me Mrs. Consolino?
Call you what?
Mrs. Consolino. I'm not here as a trustee at the moment.
Oh, did I say trustee? Sorry. Okay. I'm going to let Mr. Carroll go ahead first.
Only for further evidence.
He said he didn't have any more for her.
No, but okay, no, you can go, you're doing that. I'm at the end. I was going to give you my opinion.
Trustee Consolino, have you ever referred to any state statute before for any information?
I don't see how this is relevant.
My question is, have you ever looked into any state statute before?
I'm going to repeat, I don't see the relevancy here.
I'll make the objection on relevance. You're talking about any of the 800 sections of the Illinois Code?
My question is she aware that a code exists? Any codes exist?
All 9 volumes?
All of, not specifically, sir, that a state statute exists.
Well, I know we all have the Constitution of the United States and the state of Illinois, but a lot of people haven't ever bothered reading them. But if you're asking her if you read thousands of pages of Illinois compiled statutes, I think that's not relevant to this question. You're asking her about specific statute, I don't mind you asking about ones that relate to election codes.
Mrs. Consolino, have you ever used an attorney before when filing petitions?
Yes.
Ms. Stylen, Member Stylen?
Did you read the 2025 candidates guide?
What was that?
Did you read the 2025 election candidates guide?
Oh, candidates guide.
And on page 18, it says, on incompatibility of offices for questions concerning the same, contact the opinions of the Division of the Attorney General's office. Did you contact the Attorney General's office?
I contacted the Will County Election Board.
Okay, thank you.
You didn't answer the question. Did you read the candidates guide for 2025?
I feel that I answered the question sufficiently.
She actually kind of withdrew that question because she asked if she asked the Attorney General.
Okay, I'm asking, have you read the candidates guide for 2025?
I have reviewed the candidate guide for 2025.
Is there any further questions? Mr. Abbasi?
Yes, so what the election code says is if a candidate files for incompatible offices, this is section 10 ILCS 5, section 7-12-9, and also 10-7. If they file for incompatible offices, they must withdraw from one or the other within 5 business days. So that was yesterday. The question then is school board member and village board member incompatible? And how we determine that is...
Is he asking a question? I thought he was turning...
I was asking if you had, if you had any more questions.
Oh, excuse me, I thought I was arguing. I'm sorry, I make my argument.
Go ahead and make your argument.
No, I'm not, no. Do you have another, if you have another, I have no further questions.
Okay.
I'll let you bring the other witness.
Mr. Burgum, do you have any more evidence?
Yes, I have another witness to testify. It's the same thing, unless you stipulate that Mr. DeFalco would testify consistent with this witness's testimony about the clerk approving people running for those 2 offices.
Yeah,
Tell me and I'll call
I'm fine stipulating that,
him.
the same.
And I have no further evidence to present, but I would present that by stipulation.
Madam Chair, what the attorneys are stipulating too is that if called to testify, Mr. Fialco would testify identical to what Mrs. Consolino testified to. Is that correct, counsels?
Yes.
As to the conversation with the Will County Clerk's office, employee named Nick.
Yes.
Okay. We'll take that stipulation?
Yes.
Okay.
Is there any other evidence?
No, and I cut him off when he was starting to make his argument, so I want to remind him he was about to make his argument.
I appreciate that. I was waiting for the question as well. Okay, now what?
Now, he would argue, then you ask my opinion if you want.
Okay, Mr. Abbasi?
Yes, so the question then is member of a municipal board and school board member incompatible? And the answer is yes, despite what the county clerk says. And there was a Illinois Supreme Court decision a couple years ago. It's not in my head right now. I can find it with some searching where we had
I would agree that you can furnish that statutory reference or case law reference later.
Well, I'm saying to the fact of reliance, they're making a reliance argument, that they relied on what an agent of the Will County Clerk said. There's cases where a village clerk has given the wrong signature minimum. Candidates filed that minimum. It turns out it was a higher number. and they were still kicked off the ballot despite the reliance on what the election official had said. To get to what we look to for compatible offices is the Attorney General has given rulings on this, the Attorney General's office. And they start from, it says, I've got a couple in front of me, which is ruling 85-019 and ruling S-1494 from 1980, 85-0-19 is from 85. They go to they say the general rule is from People ex rel. Meyer versus Haas, a 1908, it says 145 ILAP 233. It says incompatibility arises where the Constitution or a statute specifically prohibits one office from holding the other, or where the duties are such that the holder of one cannot, in every instance, properly, fully, and faithfully perform all the duties of the other. And these cases deal with a city council member and a village mayor. And they say that there are a number of financial and contractual relationships that do occur and can occur between a municipality and a school board. And as such, serving on their incompatible offices, because if one were to serve on both boards, there's instances where making contracts, you can't fully and faithfully represent both of them and make decisions for both of them. You can't look out for the best interest of the school and the best interest of the municipality. And therefore, the Illinois Attorney General has said that school board member and a member of municipal board are incompatible. Because of that, because of the guidance from the Attorney General, and because the reliance argument they're making has been rejected by the Illinois Supreme Court, these offices are, in fact, incompatible. And as such, since these four candidates filed for both village trustee and one of either the Lockport High School District or District, the Homer 33C or Will District 92, and they haven't withdrawn from one by yesterday, their names cannot be on the ballot. And as such, I'd ask that this board not certify their names to the ballot and remove them as candidates for trustee.
Are you complete?
That's it, yes.
Mr. Burgum?
I don't think there's been any evidence admitted that those offices are determined to be incompatible by statute, by the Attorney General's ruling, and certainly not by those cases from 1980 or 1908. They don't address this school board and this Homer Glen village trustee position. So without any evidence that, you can't make that finding and you can't rule against them.
And I might chime in, Corbin versus Schroeder was the Illinois Supreme Court decision about relying on reliance, basically, like the argument they're making.
Madam Chair, would you
Attorney
like
Carroll.
Thank you. I believe the Supreme Court case that Mr. Abbasi was talking about, and tell me if I'm wrong, Mr. Abbasi, I think it was, could have been either Corbin versus Schroeder?
Yes.
Okay, so that is 2021 IL 127052. Corbin, Corbin versus Schroeder, Schroeder. Electoral Board, it's interesting, I have the exact same two opinions from the Attorney General that Mr. Abbasi relied upon. And while Mr. Brueggemann talked about a statute, that is one of the bases for declaring incompatibility, but the pivotal case that started this whole area of law was called People ex rel. Meyer, M-E-Y-E-R versus Haas, H-A-A-S, which Mr. Abbasi did cite. That says incompatibility arises where the Constitution or a statute specifically prohibits the occupant of either office from holding the other, or where the duties of the office are such that the holder, one, cannot, in every instance, properly, fully, and faithfully perform all the duties of the other. That first Attorney General opinion that Mr. Abbasi cited from 1980, that I had also found prior to today's hearing, deals with the issue of a village mayor and a school board member, and then Attorney General Neil Hartigan in 1985 issued a second opinion, which dealt with the offices of city council member and school board member. In both these cases, or these advisory opinions from the Attorney General's office, is that if an individual were to serve as both a city council member and a school board member, and those units were to contract, he or she would be required to protect and represent the interests of both the city and the school district. It's clear that a person cannot represent the interests of both governmental units when these units contract with each other. And that even goes back to two Attorney General opinions from 1975 and 1976. And Attorney General Hartigan goes on to say, therefore, because one who holds the office of school board member and city council member cannot, in every instance, fully and faithfully discharge the duties of both offices, it is my opinion that the offices are incompatible. And he cites the original opinion from 1980, in which it was advising that a school board member and village mayor were incompatible. The case law and the advisory opinions of the Attorney General's office make it clear to anyone that practices an election law that school board member and village trustee are clearly incompatible offices. And you could take that with what weight you wish.
Okay, so now we do a motion? Is that where we're at right now?
You could.
Okay. Is there a motion to strike the 4 candidates for filing for 2 incompatible offices without withdrawing by the deadline?
I'll make that motion.
Is there a second?
Second.
For sake of discussion. Okay, Ms. Bilski, do you have anything? Member Styling?
Yeah, the only thing is, it's listed in the candidate's guide about incompatible offices, and that if you don't file within 5 business days following the last day for petition filing, that all petitions are filed for the candidate shall not be certified for either ballot or whatever. So, and it says to contact the Attorney General's office. So I'm not the Attorney General, but from my reading and understanding, I'd have to say that I agree.
Okay. Is my understanding...
Do I understand the motion?
Sir, we're discussing. We're in the middle of discussion.
Let me know when you're finished, because I wanted to make sure I understand.
I'll let you know, sir. Thank you. So, from my understanding, as being in political office, we all know that we all refer to the state statute when there's a question. We all know that state statute overrides what somebody tells us. We also know that ignorance of the law doesn't mean that it's okay or can be overlooked. And from the state statute, I am reading verbatim. If the name of the same person has been presented as a candidate for 2 or more offices which are incompatible, so that the same person cannot serve in more than one of such offices if elected, the person must withdraw as a candidate for all but one of such offices within 5 business days following the last day for the petition filing. If he or she fails to withdraw as a candidate for all but one of such offices within such time, his name shall not be certified nor printed on the ballot for any office. However, nothing in this section shall be misconstrued as precluding a judge who is seeking retention in office, and it goes on about judges. If you look up the Attorney General website, it does state that a village trustee and a school board member are incompatible offices. And it is my opinion that we always refer to the state statute. I can't overrule the state statute. I can't make an opinion based on whatever it is that I think. For doing this for so long, we always go by what the state statute says. So I'm going to ask for a roll call.
Now,
Members-
may I respond before you- I just want to make sure what you're voting on. Are you voting that those offices of school board member in the 4 separate or 3 separate school boards, or I guess it's 4 separate school boards that people are running for, are incompatible offices? Is that what you're ruling on?
Mr. Carroll will clarify.
Council,
for you.
the motion was to strike the 4 members from the list of names that will be certified to the Will County Clerk for having filed in 2 incompatible offices. and not withdrawing from all but one prior to the deadline. So there is a finding within that motion about incompatibility, but the motion itself is to strike them from the list of names that will be certified to the Will County Clerk.
Okay, and I'm objecting to that motion because there was no evidence that those two offices are incompatible in each of the four candidates' situations.
Madam Chair. So I'll just point out to the board that there's case law and there's Attorney General opinion. So this is a legal argument, not a factual argument. You've heard plenty of legal argument on this issue.
I don't think evidence needs to be submitted since we know that they're incompatible offices. Look, I just need a clarification question, Attorney. If we were not to strike them, they would be removed regardless.
Correct.
Even if they were to stay on the ballot if we were to agree to leave them on, or if we were to agree to take them off, they would be removed regardless.
Correct. My office confirmed with both the Will County Clerk and the Illinois State Board of Elections that if this board didn't strike them, they would as soon as the names were submitted to the county.
Okay. Are the board members ready to vote, or do you have any additional questions?
I'm ready to vote.
Member Stylen?
So I'm voting to,
Strike the 4.
so, aye.
Aye. Member Bilski?
Aye.
Aye as well.
Those are 40.
Marcelino. Hayes, Modelsky,
Modelsky's been
Hayes.
Walters, and Rhodey. Let's see what's off. Next would be the discussion.
No.
And if I may, too, I don't know if this is on the agenda, but since the council had said that he's not representing Mr. Daniel Gutierrez and he's not here, I would move to find him in default and have him off the ballot for that.
May I respond?
Yes.
My understanding of the election code is you cannot default a candidate for failure to appear without some evidence. You can default an objector and strike or dismiss their objection if they don't appear. So you would have to present something on me, in the case of Mr. Gutierrez. That's one of the reasons why I wanted to clarify who Mr. Brueggemann was representing, because the standards of your burden of proof, when there's no one to argue against it, we're not going to belabor that. So that might be something we can get done in the next 18 minutes. And there's one other issue that I wanted to bring up as a housekeeping matter. I think those two things would probably take us right up to 3 o'clock. So, Madam Chair, if you want to do Gutierrez, you might be able to resolve that promptly.
Yes, so with all of the objections that Carlson filed, there was the question of people had signed more than 3 petitions. It's especially, the case for proving it with Gutierrez is easier because all of his, whereas a lot of the multiple signers were all signed October 20th, his were signed, his sheets were all notarized October 24th, after that date. I believe I counted that let me see the count again, but subtracting what he submitted 10, 20, I wrote it down, 30, 40, 50, 60, 70, 76, 78 signatures, and I believe he had 24 4+s. Since his date is later than all the others, and you can only sign up to 3, 1 per nomination, I'd asked that those 24 be stricken from his number, that he have 54, that the board ruled that he has 54 signatures, and as that is under 60, that he be removed from the ballot.
Sure. Would you like me to clarify for the board what they're considering or no?
Yes.
Okay. So we're going to have a very complicated conversation about the fact that there are allegations that many people signed more petitions for candidacy than there are openings on the ballot. There are 3 trustee openings on the ballot for this election, and there are some people that signed 15 petitions. Illinois case law is crystal clear that you cannot sign more nominating papers or petitions than there are openings for office. That's going to become very complicated for the attorneys, for the objectors and the candidates to convince this electoral board, even with the lower burden of proof that you have to consider, who signed in what order. Mr. Abbasi has a novel argument as to Mr. Gutierrez, and that a lot of these petitions that have been reviewed in this matter have a notary date of the circulator of October 20th. So then they're going to have to, the two attorneys, convince this board one way or the other who signed in what order, because what the case law says is if you sign more petitions than there are openings, so in this case there's 3 openings, the first 3 signatures count and the rest get stricken. But it's going to be to these two attorneys to convince you who's number 4 through 15. In this particular case of Mr. Gutierrez, who is not here, he's got a sufficient number of signatures that are notarized 6 days after the bulk of all the signatures we're going to be dealing with in these hearings that would bring him below the required count of 60. So it's a pretty simple case for you to decide, especially with no one here to argue against it. So take that as you will.
But I do have a question. Am I allowed to ask?
Absolutely.
We're talking about Mr. Gutierrez, where the notary date was October 24th, but if you look at Mr. and Mrs. Surgis, theirs were majority, or the bulk of, it looks like 80 on Mr. Surgis were signed on 10/26, which is 2 days later than the 24th.
But they're represented, and that'll be a more...
Oh, so that's a different thing.
Yeah, this is a little bit
this is-
lesser standard because
Okay.
he's not here to argue, and he's got an argument that it's later than a bulk of the signatures that are out there.
Right, and I'm just going through his petition sheets again. I count, so 75, 76, 78 that he turned in, and I count 25 people who signed 4 or more. So 78 minus 25 is 53, which is less than 60. So I'd ask that and again, his dates are all the 24th versus the 20th, so his were later.
So if,
May I suggest to the board that the date the notary approves the circulator signature is not proof of when the...
he's not representing this party, does not have standing to make any argument in this
Yeah,
matter.
I'm sorry.
You want to make error, that's okay.
What the board can do, again, with Mr. Gutierrez not being represented and not appearing, if you were inclined, you would entertain a motion to strike the 25 signatures that are later than the majority of the other signatures out there, certainly later than the 3 for the open office, which would bring Mr. Gutierrez below the 60 required, and therefore he would be stricken, if that's what the board were inclined to do. That's what Mr. Abbasi is asking you to do. The 25 late signatures, latest signatures.
I make a motion to strike the 25 latest signatures for Mr. Gutierrez.
I have a
For
question.
discussion. It's for discussion.
Oh, okay.
You can second it.
All right, I'll second for discussion.
Okay, so we're in discussion. Member Stylen.
So I'm looking at the objection petition for Mr. Gutierrez, and it says 96 purported votes.
96 signatures, but I believe if you go through the entire thing,
And then that's how he reduced it down to 75?
Right, yeah, it may have been a typo when I was working off the last one onto this one, but looking at his, and if you have his petitions in front of you, you can count there's 10 pages with 78 signatures.
yeah, so I did the breakdown on each one of these candidates to see who had enough and who didn't, but Mr. Gutierrez, I broke it down from 96, and then there were 8 that were non-registered voters, and then there was 5 who signed it more than once. So if you bring that down, it went from 96 to 83.
Well, and just my other question is, when I looked at the list of petition signers, like some of them are like non-registered, are they included in those numbers?
The non-registered, no.
Okay, because I mean, like some of these might be non-registered voters.
They're registered.
Okay, all right.
I believe that they're
Okay,
registered.
that's what I just wanted to make sure.
It's important that this board gets the numbers right. So if you disagree
Right.
with the 78 that Mr. Abbasi, perhaps you tell him what you've got and he can check his paperwork to see if it matches, because The numbers you're saying still would get them below 60
Well,
based
yeah,
on the argument.
I bring it down to like 58, so it is at least.
Correct.
I mean, there's probably some that could be removed that I.
Right, but you have to do a finding of fact that's specific. So
Okay.
you would have a finding of fact that he submitted X number of signatures, X or Y number were non-residents, Z number had signed the same petition more than once, so they're clearly, the second signature would be stricken.
Right.
And then you would get to the 25 that were notarized significantly later than the rest. If you were to issue a finding of fact that those 25 should be stricken, you need to make sure that all those numbers add up to a number less than 60 if you're going to strike him from the ballot.
So if I may, I'd like to do my math and see if it jives with your math.
Want to do that while we're in recess?
I should be able to get through it quickly.
Okay.
Okay. So you submitted 96 signatures. I did look to see who was registered or not. The 8 that you had submitted that were not registered, they were not. The 5 duplicates, yes, they were duplicates. So that, take the 96 minus the 8, which brought us to 88, and then you subtract the 5, which is the duplicates, brings you down to 83. 34 of them had signed 4 or more petitions, bringing that number down to 49. If you struck, you said 25, right?
You did?
Yeah, and that might be ones that you had already struck, and so
Yeah.
by your math,
He had
he's
a 59,
under
right?
60.
Yeah, it would be below 60 from my math, and my math could be wrong, because it came out to be, if 34 of them signed it twice, or I'm sorry, signed 4 or more, bring you down to 49. If you're saying 25 of them signed it later and they're going to be restricted, there's no way for him to get to 60. And the point of this is, can I just a general statement?
Yeah.
Okay. My general statement to this is, I don't know how to say this, but I don't want everyone to go away. My point is to try to figure out who can stay on with the number of, excuse me, there will be no more, okay? So it's actually, if this person was removed, it would benefit the others who stay on for the signatures. Is that correct?
Yes.
Okay. All right, that was just my question or statement.
So
So the motion has been made to,
I don't know if there's been a motion
yeah,
yet.
trustee
I did.
Bilski
I'm sorry,
made the
okay.
motion to strike,
Leave it to the clerk to know who made the motion.
and you had
I
seconded.
had seconded.
Okay, we're going to do roll call. Madam Bilski? Aye. Member Bilski said aye. Member Stylen?
Aye.
I'll say aye as well. So he's off as well.
Okay.
Now we'll take a recess.
Well, there's one other thing I was going to bring up, and so one of the other subpoenas, and this was for documents that Mr. Abbasi had requested, and his request was CC'd to his opposing counsel, was to the Orland School District 135 for paperwork involving the residency hearing of a student whose parent is a candidate for office and one of the candidates being challenged. I spoke with the attorney for Orland School District 135. While she didn't object to tendering the documents, she pointed out the Illinois Student Privacy Records Act in requiring a court order in order to release any records that even could remotely be construed as identifying a student. We tried to work through that by redacting anything involving the student's name, but it's the position of the school district, and I don't necessarily disagree with it, that anything contained in the student's file is so potentially worrisome to a school district that they want that court order. So on behalf of the electoral board, I filed a lawsuit in Will County last Thursday at noon, and I don't know if it's because of the holidays or whatever, but it took until late yesterday for them to even approve that lawsuit and give me a case number. I filed an emergency motion yesterday evening with the Will County Clerk's Office, Clerk of the Court, to try and get in front of a judge this morning so that I could get those records from the school district prior to the 1 o'clock hearing. Unfortunately, the judge that my case got randomly assigned to was just elected to the appellate court and was not on the bench this morning. So then I went to his chief judge for his division, who just retired last Friday. So I could not get in front of a judge today. I'm presuming Mr. Abbasi wants those records. I'm also presuming that I'll get them once I get in front of a judge. And so if either party thinks it would be most prudent for this board to continue Ms. Pacella's challenge until the date after that court order and release of documents is obtained. That would be my recommendation to the chair, but I'll let the two attorneys weigh in if they have an opinion.
I would agree with that.
What date are you talking about?
Well, that's for the board and the two of you to come to a date that you can agree upon. I don't want to, I did everything in my power to try and get those documents as requested prior to today's date, but for reasons way beyond my control, I couldn't. So I'm hoping to have them, clearly not this week with the holiday, but hopefully early next week. And so I would say a date mid to late next week might be appropriate, depending on what the parties wish.
Would, if we said maybe Friday of next week, would that give time to give the other issues, like registered voters issues, to the Will County Clerk to have whatever report they need to do on voters being registered or not, or?
May I respond to that? So my thought is that particular candidate, if I recall, there are 3 or more challenges that you filed. I have a feeling that that group of challenges for that candidate will be lengthy. So what I would recommend to this board, if they're inclined to continue that one, is continue that to a date that does not match up. If we don't finish all 15 today, for example, and we have to continue up any other cases, I would recommend that one be given its own date, because that potentially the challenges involved, in my opinion, and you may disagree, could take a while.
Well, I would rather, I mean, I'm not trying to tell you what to do, but I would rather have just one more date after today that we could come back on the others, including your subpoena issue. If that's Friday, the 6th of December, that's fine with me.
I'm not opposed. It's up to the board. I mean, obviously, there's going to be a discussion on between yourselves on how to handle the rest. What are we doing here?
So is everyone available on the 6th if we were to continue her case?
I'm available on the 6th.
Okay.
Member Bilski, are you?
And Mr. Brugman, my thought is we could address the rest as we go through the day today, and we may continue in the same date, but that's really up to the two of you. I'm just thinking her challenges, based on what I've read in the petition or the objection, might take quite a while.
Well, again, my suggestion was if we're continuing anything, we should all continue it all to the same date, and if that's December 6th, that's okay for me.
Okay.
I'm not telling you you have to continue.
No, I get it, I get it.
Okay, we're all available after 2 p.m. or 2 p.m. or after this board.
On the 6th?
I lied.
Oh, yep.
On the 6th,
Yeah.
4 p.m.?
I'm not available at all.
On December 6th. Okay, what date are you available? Monday, how about December 10th? After 1, we have the HR training.
Yeah, I was just going to say that. But yeah, we can miss that.
Are you, Mr. Abbasi, are you available December 10th at 1?
It's a Tuesday,
Wait, when does the,
19th, they have to be certified.
okay. Thank you for reading my mind. Are you available on the 10th?
I believe I am. I'll call my office in just
Sure.
a second and ask them that, and then I'll tell you for sure that the 10th at 1 o'clock is okay with me.
1 o'clock?
Let me call.
Sure. If you want to make that call, we're all available.
Well, we're going in,
We're going to recess anyway, so yeah.
you don't have a
Oh, we're going to
clock
I'm
up
gonna tell you,
here.
but I gotta be your judge in 2
Okay.
minutes.
He wants to get out of here at 3. If you want to get out of here for your 3, it's 2:57. I'll make the
Are we
call.
returning after? Are we doing
I'm
recess?
gonna take me
Okay.
15 to,
Okay.
well, according to Joe, there's only a few cases, so I should be done in 15 to 20 minutes.
Okay, so we're going to take a 20-minute recess right now.
Okay.
And I'll check with my office on that date.
Okay.
Where's the admin?
Okay, we're bringing the court back to order. Attorney Carroll?
Madam Chair, there are some motions that the attorneys for the various parties wish to make. I think Mr. Brugman stepped out for a moment.
No, I'm right there.
Oh, I'm sorry. You're right behind Ruth. I'm sorry. Okay, who wants to go first?
I had previously, or my partner had previously made an objection to the constitution of the board with 3 people who I thought all 3 were supporting 3 candidates for this upcoming election. I think one of them said she wasn't. So my objection is that people who are supporting candidates in this election shouldn't be sitting on the election board. That I'd make a motion to remove them again.
Madam Chair, that's already been adjudicated, so you could just note his objection for the record, but I don't think it's appropriate to bring it up again.
I'll note your objection for the record.
Thank you.
Madam Chair and members of the board, I'd like to move that the declaration of Michelle Navarro that was entered as evidence in case 01, where Cesar Milano is a candidate, we had discussed at the beginning, but we hadn't actually done the redaction of the candidate's minor child's name, and I'd ask that, I'd move that that be redacted in, when this is in the record.
Madam Chair, my understanding is both sides agree to that, and I think that
Yes.
would be an appropriate redaction, and if, with your authority,
Without waiving my objection to the document in general,
Correct.
I think it is necessary to be redacted, and you can make the redaction according to Mr. Abbasi's request, and I have no objection to you making that redaction for him.
so I will, with the chair's permission, I'll work with the deputy clerk to make sure the final record has that redacted.
And also, for purposes of the record, I know I had referred to at least one witness by their elected title of trustee, and I believe some of the members of the board had as well. I'd ask that that be redacted in the record.
That would be,
I have no objection to it. I think that's appropriate.
That would be appropriate.
Just so we're
We
clear on
already
how-
talked to the court reporter about how we do that, because she has to actually prepare it verbatim, and then we can redact it afterwards.
Madam Chair, may I ask Mike from the village whether this is being streamed like the last one was?
Yes.
Is it?
Mr. Pierce?
Okay. So our concern, and obviously the court reporter's concern, is that her record reflect what's going to be on the video. So I think the proper method to handle a redaction of that nature, and the attorneys, and I spoke about this during the recess, would be for us to redact it once we get the transcripts from the court reporter, so her official product is accurate. But anything that was going to be transmitted from the electoral board, say for instance, to the circuit court of the 12th Judicial Circuit in Will County, would have the redaction because, you know, as we all know, we're creatures of habit, and we make mistakes in titles, and they're honorific, and we do it out of respect, but they're not appropriate for this electoral board. So I think with the two attorneys, and I can handle that with your permission, Madam Chair, once the transcripts are finalized.
Yes.
Okay. The other thing the electoral board wished me to tell the attorneys, which I already did in recess, but we'll put it on the record, is for any of the candidates that are wishing to take up the actions of this electoral board, your time clock does not run starting today. There has to be a final written ruling, and then you have the time period to file any objections to the final written ruling once it's issued. It is my hope that I will draft written rulings based on the verbal rulings that were given today, and they'll be transmitted to the candidates or their attorney, whoever's here in court on the 9th, which is, I believe, when we're going to commence and continue this. That's up to the chair. She'll talk about that next. But whatever date she picks, I'll have orders drafted, and assuming that those orders are acceptable to the 3 electoral board members, they'll be transmitted to the candidates on that day, and that starts their time from which to file an appeal. Does that accurately reflect what we were talking about, councils?
It does on our side.
Counsel?
All right, Madam Chair, was there a date that we all agreed upon? I believe it was 12/9 at 2 o'clock, if that's
December
matches.
9th at 2 o'clock. Is that, you're available, Member Bilski? Yes. Member
we've-
Stylen?
We've kind of indicated if we need to run late, you will, I
Yes.
think. Is that what you said, to finish it on the 9th?
Yes.
I'm not putting words in your mouth. I
No,
don't.
that's what we
I'd like
agreed
to get them
to.
done if we can, because we're,
That's what we're committing to if we can.
yes.
Yes, I intend to be here till we get through all, is it 6 remaining cases, I believe?
You have my sheet, so I don't know.
We have remaining Ms. Pasella, Mr. and Mrs. Hayes.
No, just one.
No.
Oh, Miss-
Just John Hayes.
Oh, that's right, okay. So Pasella, Mr. Hayes, Mr. and Mrs. Surges, Mr. Kukul. That's it, 6.
And Pesmino.
Oh, and Pasmino, so 7
Is it?
or 6, I don't know.
Math is hard.
6, I said 6. So 6 cases left.
So, yes, Council, I believe it's the board's intention to try and grind through all 6 of those on the 9th, starting at 2 o'clock.
Great.
Okay, thank you.
Thank you.
A motion to adjourn.
Meeting, okay, is there a second? Okay, Meeting's adjourned.